In this next panel, we've got Amy Cohen, Bo Dahl, Ryan Macias, and Howard Knapp, as you can see on the screen there. And I'm going to hand it over to Amy.
Thanks, Judd, and thank you to the Humphrey School for having me. I'm really looking forward to this panel. We don't have slides, so if we want to take that slide down, I think that would probably be helpful. Then at least I'd be able to, thank you. Then I'd be able to see everyone. We are joined today, or first of all, I'm the executive director of the National Association of State Election Directors, and my members are in all 50 states, DC, and the 5 US territories. And I'm excited to be joined today by 3 current and former members, and people I really enjoy. And so I know this is going to be a really good conversation. And I also want to thank Justin for doing such a great job sort of teeing up some of the big picture issues. We're definitely going to be referring back to some of the things that he said. So first we have Bo Duell, who is the former director of elections for Arizona Secretary of State Hobbs, and was the general counsel for Secretary Hobbs. And then she followed now Governor Hobbs to the governor's office and was the general counsel for Governor Hobbs, and is currently an attorney with Coppersmith Brockelman in Phoenix. And we are joined by Howie Knapp, who is the executive director of the South Carolina State Election Commission, which makes him the chief election official for the state of South Carolina. And last but certainly not least, we are joined by Ryan Macias, who is the former election technology analyst for the California Secretary of State and the former acting director of the EAC's Testing and Certification Division, former cybersecurity and election technology consultant for CISA, and the current owner of RSM Election Solutions. So we're covering a lot of ground here today. So first, for everyone, and I guess I'm gonna start, I think, with Ryan, and then we'll go from there. But what were your initial reactions when you first heard about the executive order in March? I know what my first reaction was, and so in mixed company, I'll ask what was your first reaction?
Yeah, thank you, Amy. My first reaction was uh, looking at the legality. Obviously, I'm not an attorney, and Justin just dug into, the legal issues. But it was a sigh. I was trying to understand exactly what it meant, trying to figure out the breadth of everything that was in the executive order, but then ultimately started digging into the sections that were related to the technology and security. So specifically Section 4 and Section 6, to take a look at it and understand what, if anything, these recommendations from the president may be able to be implemented. And then also to understand which portions of it just could not. And so talking to a lot of elections officials about that, and I know we'll dig into that in just a minute, but that was my initial reaction.
Thanks. And Howie, as a chief election official, what was your first reaction?
So when I first heard about the executive order, I had a lot of questions, and we continue to have a lot of areas that still require clarity. In South Carolina, changes to election law traditionally come through our General Assembly. And so we're kind of working with some of the members of our General Assembly to amend certain sections of our election code to conform with some of the aims of the executive order. But what we need from a state level is clear guidance and timely communication from the feds. That's going to be essential. To be quite honest, getting the same answer about what this or that means from different entities at the federal level it's just not happening right now. So that was our initial reaction. That continues to be our current reaction. So we're kind of in a holding pattern right now.
Thanks. And then Bo, from where I think you were still in the governor's office at the time. So what was your reaction?
Yeah, thanks so much, Amy. when I heard about the executive order, I was the general counsel in the governor's office at the time. And I think like most election and state officials that I knew at that time, I was very alarmed and very concerned. I had been, as you noted, the state elections director in Arizona during the 2020 election on January 6, 2021, when Arizona's electoral college votes were the first to be objected to in the joint session of Congress on baseless allegations of fraud. And then during the 2021 Cyber Ninja's sham audit of the election in Maricopa County, Arizona, that really did immense harm to voter trust in elections in Arizona, to say nothing of the heavy burden on election officials who were just trying to do their job and the threats and harassment that it brought on. So this executive order really brought on for me a little bit of PTSD, and it was really upsetting to see those debunked claims of fraud repeated in the executive order now, 4 or 5 years later, and magnified again in this way. So it's like, are we ever going to move past 2020? But after reading the EO more carefully, it became pretty apparent pretty quickly to me that, as Justin noted earlier, all of the significant pieces of it were not within the president's authority to dictate, and that it would be swiftly challenged in court, and that a lot of it would never actually take effect. But those realizations, after digging deeper into the text of the order, those realizations really didn't lessen my concerns, my initial concerns. Because even if no provision of this executive order ever takes effect, as a former election official, I can just see how it lays the groundwork for ongoing harm and foreshadows a really long and hard battle ahead of us against further election lies and efforts to subvert elections, battles against politically opportunistic undermining of sound election administration that election officials work hard to implement every day. So to me, it was just, if any of us had any hope that that we were out of the woods a little bit in terms of returning to some pre-2020 state of the election information ecosystem, this EO signaled really loud and clear that we are so not out of the woods.
Yeah, I think that's definitely true. We continue to be very, very popular. So digging in a little more into some of the sections of the EO, when we talk about documentary proof of citizenship, Arizona is always the state that we talk about because it's been the law in Arizona for some time now. So Bo, can you talk a little bit about how it came to be in Arizona and how it works really in practice for election officials and voters? Like, what does it mean on the ground?
Mm-hmm. Yeah, happy to talk about proof of citizenship. We've had it for a long time in Arizona, as you know, Amy. So it actually came about through a citizen initiative in Arizona in 2004. I think we were the first and only state requiring that for a while. And then there was as with other significant changes to election procedures, it was subject to a lot of litigation, culminated in an important 2013 U.S. Supreme Court ruling called Arizona versus Intertribal Council of Arizona, which has featured prominently in the recent litigation over Section 2A of the executive order. But the Supreme Court there in 2013 held that the National Voter Registration Act requires Arizona, despite this citizen initiative that had passed requiring proof of citizenship, the federal law requires Arizona to accept and use the federal form and prevents the state from imposing additional proof of citizenship requirements to register for federal elections using the federal form. But the state, of course, can require proof of citizenship to register to vote for state and local elections. So that's how we arrived in Arizona at having this pretty complicated bifurcated voter registration system. So on the one hand, you have our regular portion of the voter registration list where Arizonans who provide proof of citizenship, they are registered as full ballot voters. They're eligible to vote in all races, federal, state, and local. If you don't provide proof of citizenship, you're registered as a federal only voter. That means you can't vote in state and local races, and you would get a ballot that only has the presidential and congressional contests in it. So I think right now we have about 45,000 federal-only voters on the list. That's less than 1% of the state's voter registration rolls, just for context. And of course, for context, I have to stress that actual cases of non-citizens illegally voting are exceedingly rare in Arizona or anywhere else in the country. There's just no evidence that it's happening at any meaningful level. So Arizona's had this requirement for over 20 years. It should be a well-oiled machine, should be smooth sailing from an implementation standpoint at this point, right? Wrong. Some of you may have read about what happened in Arizona last year, and the Arizona Supreme Court's ruling on it right before ballots were to go out for the November election. And we'll talk a little bit about where things stand now, which almost a year later is still in some limbo. And I'll disclose that I was very closely involved with in handling this matter for the Arizona governor's office when we were dealing with it. And I'll also disclaim that, the opinions I'm sharing here are obviously my own and not the governor's office's. But to understand what happened last year and to see how, this has worked on the ground, you have to back up a little bit. In Arizona, we actually have a pretty voter-friendly citizenship proof process because we accept licenses as valid DPOC, and our voter registration system talks to the MBD system so it can transmit that license information directly. The voter doesn't have to submit anything if they have an Arizona driver's license that indicates that they are a US citizen. So it's much easier for voters than what seems to be contemplated by either the SAVE Act or the president's executive order, which would require voters to actually submit a photocopy of the proof. So the vast majority of Arizonans register online and their proof of citizenship is automatically transmitted. But only licenses that are issued after 1996 can serve as valid proof of citizenship. And why is that 1996 date significant? It's because that's when Arizona started requiring proof of citizenship to get a driver's license. And the systems talk to each other, and the interface was designed to notify election officials that are processing registration forms if the license is issued before 1996, so they know not to use that license as proof of citizenship. The big problem that came to light last year was that for MBD purposes, if you had a pre-96 license, you get a duplicate or a renewal, the MBD system updates the issuance date to the new date. So it'll be a post-96 date because you got the renewal, even though under the registration law, that's not a valid proof of citizenship document. This was widely reported as an MBD data error or glitch, but this logic was actually perfectly correct and necessary for MBD functions and data needs. But the problem was in how the systems talk to each other. And for voter registration purposes, it meant that people in this bucket, they weren't flagged as having pre-96 licenses. So election officials erroneously relied on these licenses to register people as if they had provided full proof of citizenship when they had not. So when this problem was discovered last year, state officials were able to work pretty quickly together to implement a forward-looking fix to the computer interface, but we were left with the question of what to do with the approximately 200,000 registered voters that were affected by this, meaning they hadn't actually provided proof of citizenship, but they were registered as if they had. Arizona is a closely divided swing state. We've been in the news a lot for that reason in the last cycles. And 200,000 voters is a big number. It could impact the result in a lot of important races. So all sides agree that we needed an answer quickly, and that we needed to get clear and quick ruling from the highest court in the state. We needed in time for election officials to be able to comply so that this issue can't be a basis for challenging election results after the election if you happen to not like the results. So the Maricopa County Recorder sued the Secretary of State on the issue, bringing a case directly in the Arizona Supreme Court. The Supreme Court thankfully ruled quickly and said that county officials could not require the impacted voters to provide proof of citizenship to vote in the November election, but didn't give guidance on what needed to happen after the November election. So the predominant assumption last fall when this issue first arose was that after what do we do before the November election? It's too close. But after the November election officials could give the affected voters proper notice, give them a chance to respond and provide the necessary proof of citizenship. And if they don't, then move them to federal only, because that's what they should have been registered as in the first place. But some counties, because of a number of different reasons, which we don't have time to go into, they took the position that if the voters didn't respond and provide proof of citizenship, you have to cancel them altogether, like not just downgrade their records, but remove them from the voter rolls altogether. Earlier this summer, the Secretary of State asked for an AG opinion to try to get some clarity and uniformity on this. And the AG recently, just a couple weeks ago, issued her opinion, which actually threw a third interpretation into the mix. The AG determined that the counties don't have authority under state law to do anything to these records. They have to stay as full ballot voters, even though they were registered as full ballot voters erroneously in the first instance. And AG opinions in Arizona are not binding on public officials. So I anticipate there will be some county recorders who control voter registration directly who don't agree with this opinion and who choose not to follow it. So the state will be stuck in a circumstance where we have voters being treated differently, these 200,000 voters, depending on which county they reside in, and necessitating further court intervention. So Arizona's experience, and especially what we went through last year, I think is just a cautionary tale for states considering similar laws, and really for the whole country if Section 2A of the executive order were to ever take effect. For states looking to implement citizenship proof requirements, you should expect to spend just a lot of time and money to make the system work well. And even then, there will inevitably be issues long down the road. So you have to modify voter registration forms and processes and systems and voter registration systems. You have to educate voters on these new requirements. You have to retrain election officials on processing voter registration forms. And you also have to acknowledge that some otherwise eligible voters are going to be prevented from registering and voting as a result of this requirement. So I think, the lesson from Arizona is that implementing a proof of citizenship requirement is a massive undertaking, and there are significant and messy complications that can emerge even decades after the requirement takes effect. And states really need to weigh that against the reality that the problem that this is intended to solve, the problem of non-citizens voting illegally, that problem is virtually non-existent, and one that is addressed through other procedural protections that are already in place throughout the election process and through very serious criminal penalties that are already attached to this conduct that's already in the law. So that is my proof of citizenship crash course from the great state of Arizona.
It's helpful, and it's especially helpful to think about some of the long tails of policy changes, right? It's not just when you first implement it, things come up down the road. And that's with any policy, but it's helpful, I think, for everyone to hear the Arizona experience here. Turning to this section of the EO that has monopolized a lot of my brain space, which is Section 4B. Ryan, nearly all of the voting equipment in the US is certified to the Voluntary Voting System Guidelines, VVSG 1.0, which was adopted in 2005. And the VVSG 2.0 was adopted by the EAC in February of 2021, and they just certified the first 2.0 system in July. So that's another sort of long tail on that implementation. But can you talk a little bit through the process of developing new guidelines as laid out in the Help America Vote Act, and how, if at all, does the EO diverge from that process? Few know the process the way Ryan knows the process, so we're in the presence of an expert here.
Yeah, thank you, Amy. As you alluded to, the Help America Vote Act, and so the Congress actually laid out the process for adopting voluntary voting system guidelines, as well as modifications to any existing version. This is set forth in Section 222 of the Help America Vote Act. And so ultimately, the process begins with the Independent Advisory Board, which is called the Technical Guidelines Development Committee. They have to make a recommendation to make a modification or adopt a modification or a new version. Section 222 specifically states that the executive director of the commission shall take into consideration the recommendation provided by the TGDC, or the Technical Guidelines Development Committee. Once this takes place, then it has to go through the other boards. So the EAC, under the Help America Vote Act, has 3 independent advisory boards. These are they're what we call a Federal Advisory Committee Act board. And their role is to advise the EAC on different things. And so once the TGDC, as an advisory board, an independent advisory board, advises the EAC to adopt a new version of the VVSG or a modification to the VVSG, the executive director then sends it to the other 2 boards, the Board of Advisors, as well as the Standards Board. These boards have the opportunity to review the current version, to make additional recommendations, to vote on the recommendations, and to advise potentially for additional changes or modifications. Once the 2 boards make those recommendations and vote on it, then the EAC has to publish for public comment. So not just from their 3 advisory boards, but also for public comment as well. This is required to be a public comment for 90 days. And the Help America Vote Act, Section 222, says that it can start at the same time as the boards are reviewing it. So it would be 90 days in totality. But then ultimately, the final step is the commissioners must vote on it. And so they are supposed to take into consideration the recommendations. So if the board say that they don't like the recommendation that the TGDC made, or they want to see additional changes or modifications, the executive director is supposed to take into consideration, make updates, make changes, and then ultimately it takes a vote by 3 of the commissioners to adopt a new version. So then to the point about how does this diverge? Well, this diverges because the EO is a recommendation by the president for the EAC to just make modifications, not to go through the Help America Vote Act process that the Congress has laid out. Rather, it is the president making a recommendation that the EAC just make the change. And so it diverges from, again, the process that the Help America Vote Act laid out. It diverges from what the Congress has set forth. And ultimately, it bypasses these advisory boards, whose role under the Federal Advisory Committee Act is to act independently and advise the EAC on whether or not they should make changes in the first place. And so the Technical Guidelines Development Committee, again, as an independent body, needs to first make a determination as to whether or not they want to recommend a modification to comply with the EO. Otherwise, the process can't be set forth.
And how is it playing out so far, right? Like what has been going on so far with the update process?
So currently, the Technical Guidelines Development Committee is meeting to make that determination as to whether or not to recommend these changes along with the executive order. And I should also back up and state that there's also multiple policies that the EAC has adopted over time that impact what can go into a modification and what can be updated or changed throughout or inside the VVSG. But currently, the TGDC is meeting to make a determination as to whether or not they should recommend the changes in the EO, whether or not they want modifications to be made to the VVSG 2.0 in the first place, and to adopt either a version 2.1, which would be minor modifications, or whether they want to make significant changes and create a new version, which would be the VVSG 3.0. But secondarily is the EAC went forth and decided to go ahead and draft a version 2.1 on its own to bring forward to the TGDC, to basically ask it to review instead of first coming to the TGDC to make the recommendation, as has been done in past precedent.
Got it. Thank you. And, one of the other, I think, very important pieces of Section 4B is about the decertification of voting equipment. Can you explain at a high level the current decertification process that's laid out in the VVSG manuals, and I think provide some important historical context about whether or not voting equipment has ever been decertified under this process?
Yeah, so you referenced the manuals. So I'll go ahead and start there. I'm going to actually back up a little bit before I get into the decertification process. So as I was stating, the EAC has policies that they have adopted throughout the process to meet HAVA Section 231, which requires the EAC to, I'm going to quote it, provide for testing, certification, decertification, and recertification of voting systems. And so, the Help America Vote Act tells them that this is their responsibility. This is one of their roles and duties under the Help America Vote Act. So in order to provide for that testing and certification, decertification, recertification, the EAC has adopted a policy, which they call the Voting System Testing and Certification Manual. The manual lays out a lot of different things. It is actually what lays out that the VVSG will be the requirements by which a voting system will get certified. There's nothing in the Help America Vote Act that actually says the VVSG is a set of standards for certification. As a matter of fact, Section 301 is called the Voting System Standards. So those are the only standards that are set forth in the Help America Vote Act. It is this policy that the EAC has adopted through the Voting System Testing and Certification Manual that provides for the testing and certification, and says that the VVSG will be the requirements by which we will test and certify against. But also, in Section 7 specifically, it lays out a very in-depth process for decertification. Again, this is the policy that the EAC has adopted to meet the requirement to provide for decertification. And it's, like I said, it's a very lengthy process. I'm going to hit it at a very high level, but basically it starts with what we call an informal inquiry. Someone has to say, we believe that a system should be decertified because it does not meet the requirements by which it was tested and certified against. So as you had mentioned, Amy, right now, all except one system has been certified against VVSG 1.0. Therefore, someone would have to provide an informal inquiry that they believe that the system does not meet the VVSG 1.0. That is not what the EO says. And I'll get to that in a minute. But if the EAC determines that they are going to take this inquiry, they can start what they call a formal investigation. And so this is for the staff to look into it and say, do we believe that there is a non-compliance? Do we believe that a system is not compliant with VVSG 1.0 in the example that I'm giving? And then the next step is, if they believe that it is not in compliance, they shall send a notice to the voting system vendor, or what they call a manufacturer, to tell the manufacturer that their system is not in compliance. There also must be a formal written decision on the decertification after the vendor has been notified and the vendor has had an opportunity to be able to respond and or cure the non-compliance. The next step would be that the manufacturer takes that opportunity to go ahead and cure. So they would write saying, we can cure it. This is what we're going to do. And then the EAC would write a written decision on decertification. If they do not move forward and cure, then there is a formal decision on the decertification. After a formal decision on decertification is actually issued, the vendor then has an opportunity to appeal that decision. Once the appeal goes forward, then there is a final decision by the commission to basically write their decision on the appeal. So unless the EAC adopts a new policy, it can't actually fulfill Section 4B of the executive order, because the EO asked the commission to decertify systems that are certified against VVSG 1.0 for not being compliant with VVSG 2.0 and additional requirements that the president has requested in the EO, which have never been incorporated into any set of requirements. So the EAC policy doesn't allow for decertification for what the president has suggested, nor could the EAC, I should say, even if the EAC went ahead and modified its policy by a vote by 3 commissioners or unanimously to change its policies, it doesn't even have a new set of requirements that include the president's suggestions for it to be able to claim noncompliance against. And then I think the second question you had asked was, has the decertification process ever taken place? Or how many systems have been decertified? And the answer is 0. So the EAC has never decertified a system. The process has been initiated. And so that long set of steps that I kind of went through, that process has started. They've initiated decertification. They've conducted formal investigations. They've even submitted notice of noncompliance. However, through the curing process, the vendors have made the modifications that were necessary. And interestingly enough, because it's an actual modification, they end up creating a new system. And so with a new version number, which then goes back through the testing and certification process. And at that same time, the vendors who have had this issue occur decided to request a formal or to withdraw their certification of the system that is not compliant before a decertification was ever issued. So they made the cure, submitted a new system, and then formally withdrew the certification voluntarily, saying, I don't want this other system to be decertified. Rather, I will withdraw it because I created a new system that cures the issues that you are looking at.
Thank you. I know Ryan and I could probably talk about just Section 4B for the next 3 hours. But I want to make sure that we are sort of covering a lot of this. And Howie, we haven't forgotten about you. There's been a lot of coverage of the communications from DOJ to states, and I know there's a whole panel on it later. And not all of it is under the EO, but some of it has either referenced the EO or been sort of part of the EO. And so in your experience, is it common for DOJ to communicate with state election offices? And what kinds of things would they normally be reaching out about? And what, if anything, makes the sort of outreach that we're seeing now different?
Sure. So we've never had a request like this from the DOJ in recent history, I should say. It's not unusual for the Department of Justice to communicate with states, their chief election officials, on various things. It's usually related to federal enforcement of federal election and voting laws. It's usually involving local election offices, county election offices complying with federal law. So a good example of this would be making sure our polling places in South Carolina are ADA accessible, which is a challenge that has been going on probably since the ADA was passed. But that's the kind of communication we've typically received from the DOJ, and that communication would be directly to the local county election office, and we're CC'd on it. But that's really the full extent of what we've seen recently.
Bo, in your experience in Arizona, when you were both the election director and when you were the general counsel, were you in receipt of communication from DOJ, sort of similar to what Howie was talking about, or did you guys see anything that was different from that?
I'll just say what we're seeing right now was not common in my time as the state elections director. As Howie alluded to, the correspondence we would get from DOJ were more targeted towards specific issues and specific enforcement efforts, and less appearing as a sort of fishing expedition and asking for, broad swaths of data for information that's otherwise protected under both federal law and state law. So I would just say at a high level, this is uncommon.
It's helpful. That is one of the most common questions I'm getting from the press is what kinds of things have states heard from DOJ about in the past? So Howie, I have another question for you. You know, they talked about it a little bit in the previous panel, but Section 7 of the EO would prohibit ballots that are postmarked on or before Election Day from being tabulated if they were received after Election Day. And so what would the effect of that be in South Carolina?
So in South Carolina right now, our current election law requires all ballots must already be returned by 7 p.m. on Election Day. The only exception to that would be UACAVA, and the voters who are covered under the Uniformed and Overseas Citizens Absentee Voting Act. Those voters can, their ballots can be accepted after Election Day if that ballot is received no longer than the day the election is certified. So that could be a few days to a week later, but that's frankly a very small segment of our voting population, our UACAVA voters. So it's, when it comes to the post office, there's a lot. I mean, I'm not going to go into all the issues we've all had with the post office in the last 2 presidential election cycles. But we've had issues. So I think this part of the EO actually misses a bigger problem with just absentee voting in general, and not absentee itself, but just the post office and the large number of issues we've had in our state. I don't mean to co-opt the question, but that's really when we read that in South Carolina, like I said, we largely already comply with that, but we've had major problems with absentee ballots in terms of relying on the USPS to do their part.
Yeah, I think that experience is echoed by states across the country. So Bo, you left the governor's office not that long ago, and in most states, the chief election official is a separately elected constitutional officer. But do you have a sense for how governors generally are reacting to this EO? I know there's been a lot pushed onto states over the last few months, and certainly a lot of EOs that directed at states, but I'm curious specifically about this one, what your sense is for governors broadly and how they're responding to this or feeling about this.
So even though governors are not the chief election official in our states, they still often play a really important role in elections. So for example, many governors, like in Arizona, play a role in the official canvass of the state election results. And in Arizona, the governor approves the state's election procedures manual, which is kind of the nitty-gritty in the weeds rule book that is binding on state and local officials and how they administer elections. So all that's to say is governors are still important actors in election matters. And as to the EO, I think in the current political environment, the response from sitting governors has been sharply divided along partisan lines. It mirrors the broader kind of national battles over voting rights and election administration. You see Democratic governors largely taking a public stance against the EO and often working with or otherwise supporting their AGs and secretaries of state in litigation and messaging, expressing those concerns. And then we see Republican governors, on the other hand, either endorsing the EO or staying quiet, and some portraying it as being consistent with election integrity measures that are already in place. So I guess I'd say it's not been all that different from responses we're seeing from sitting AGs and sitting secretaries of state. But among former officials, though, I think across the board, governors, AGs, secretaries of state, we're seeing more bipartisan concerns raised about the EO's overstep and the potential for it to harm election administration and election integrity generally.
Thanks. And Ryan, I have a variation on the same question for you. What are you hearing from the election technology vendor community about the EO? We talked about voting equipment earlier in this conversation, but in addition to Section 4, Section 6 of the EO talks about DHS and the EAC reporting on the security of all systems used in the voting process, which is a much longer list, I think, than people might realize. So what kinds of things are you hearing from our technology community?
Yeah, so we're really not hearing a lot about Section 6 specifically. And I think the reason is, Amy, you're talking about, that there's a lot of technology that is used in election infrastructure and in the conduct of elections. But ever since the designation of critical infrastructure, CISA, the Cybersecurity and Infrastructure Security Agency, and I know there'll be a panel on them later, but they have already been conducting risk assessments on all of election technology and all of election infrastructure since that designation. And so they are an agency within the Department of Homeland Security. So basically what is mentioned in Section 6 is for CISA to continue doing what it's already done. I think back to some of the risk assessments that CISA has already conducted on voter registration systems, election results reporting, on technologies used to facilitate mail-in voting, on electronic ballot delivery and return technologies. And many of these were worked in coordination with the EAC. So again, if you look at Section 6 of the EO, it says that DHS, in coordination with the EAC, shall assess the risks of these technologies or take a look and write a report. Well, those reports are written on an ongoing basis every single year. And the risk is being assessed on an ongoing basis by CISA. So, but what I think the fear from both vendors and elections officials alike is to what extent DHS is gathering the data to assess. So to date, all CISA services is voluntary, but what we're hearing right now is that either the DOJ or the DHS are coming out and saying, are requesting of states that they turn over their systems, that they turn over their data so that they can conduct these types of assessments. Previously, it was always very voluntary. We said CISA, would talk to the vendors, would talk to localities, would talk to elections officials alike, and say, as an organization, CISA can provide these services. And these are the services that CISA gives to all critical infrastructure. But elections officials, if you would like to partake in it, you can voluntarily sign up. So there is a concern that the EO may try to direct the Department of Homeland Security and or the EAC to kind of remove that voluntary aspect and tell them to go in and start assessing these systems as we're, like I said, as we're seeing occur right now. The additional issue that we're hearing from both elections officials and vendors is the concern that CISA no longer has any expertise on these systems. With the elimination of the election security mission and the firing or pushing out of all of its staff, all of its consultants, who have worked in election infrastructure security. Many elections officials and vendors are concerned how accurate, how reputable any future assessments may be. And so the fear, basically, this is the fear that I'm hearing from both vendors and elections officials is what expertise do they have to assess the data? What is any report going to look like that comes out of the data that they are assessing? And then are they going to try to force themselves into our election infrastructure rather than having it be voluntary as it's always been?
Thanks. I think that's a really good sort of holistic look at it. And it's worth noting for people watching that the relationship between election officials and CISA and its predecessor agency, NPPD, was not always as close as it became, right? When elections were first designated critical infrastructure in January of 2017, it was a much more fraught relationship. And there was a lot of discussion of it, growing into an arranged marriage and, then perhaps a marriage based on appreciation. And so that did take a long time to get there. And so a big part of getting to that growing appreciation on both sides was the voluntary nature of the relationship because states administer elections. Howie, what are you hearing from your peers and your local election officials about VEO and especially voters? Are you hearing anything from voters? I will say I'm hearing from my mom a lot of questions. And so one can only imagine what election officials are hearing directly.
Yeah, so for my peers, especially in the southern region of the United States, we're all kind of in a holding pattern right now. Let's just be honest, this is a very hotly political issue, especially for Republican states. So we're all just kind of waiting to see what happens. Luckily, a lot of this is in the hands of the courts. So I can tell you from my state's perspective, the elected leaders of my state I'm not really getting feedback from them right now. I think they're also just kind of waiting to see what the courts hold. And like I said before, there are some aspects of the executive order that I think some legislative leaders would like to see made into law. And I'll just give one example, which is, in South Carolina, when you register to vote, you have to affirm that you're a citizen, but there's no requirement that a person prove they are a citizen. So there's some interest in making that proof of citizenship upon registration a requirement. And I'm not saying that will become law. I'm just saying that there's conversations of that happening. In terms of voters, when the executive order first came out, we got a handful of communications from constituents about, really just asking us, what does this mean for us? And unfortunately, we have to say, we don't know. We're still trying to figure that out. So kind of what I said before, no matter who I'm talking to outside of the state, whether it's my peers or just nobody seems to have a straight answer of what's going on. And that's the most frustrating part for me is the lack of communication and direction and clarity throughout the entire process. Aside from the policy standpoint, aside from the legality, just the clarity of what's going on I think is what's needed the most. But I'm keeping, my governor, my attorney general, my legislative leadership apprised. I sent a very brief high-level memo to them saying, hey, here's the executive order. Here's how it might conflict with our state laws. Do with it what you will, because frankly, it's in the hands. If we want to completely conform our laws to the executive order, which I'm not saying we do, these are the changes that would have to be made. So I'm just keeping the decision makers apprised of what is going on. I've been saying since I was appointed, it's my job as an executive branch official to carry out the law, not to make the law. And it's the court's job to interpret that law. So I'm sitting and waiting, which is what we do best in the executive branch.
Ryan, I guess I'll ask this question of you too, because I know you are in touch with a lot of local election officials in particular nationwide. Like, what are they hearing from voters about the EO, or is my mom the anomaly?
No,
Possible.
I think there's a lot of questions. Again, there's a question of the legality of it in the first place. I think we're seeing a lot of that kind of in the chat and the Q&A that we have right now is, first and foremost, is this legal? But that's usually the people who are paying very close attention. Then there are, the everyday voter. And what they are hearing is that this is required. And so there's this kind of constant confusion of, particularly, around 4B, around the barcodes and so on and so forth. It's like, well, my state has barcodes. Does this mean my system is going to be decertified? Does this mean that my system is not secure? Does this mean that my vote will be illegitimate if I vote with a system that has a barcode? And so on and so forth. So I think there's, what elections officials are trying to do is describe, as Howie just did very eloquently, is, we're in a wait and see pattern. We're waiting to see what happens. States have the rights, under the Constitution. And so if it is not a state law, then it is likely not going to occur. But then you're also seeing some local jurisdictions whereby they're being pressured to make the changes. And so that's creating additional confusion amongst the voters in those specific states. It's like, well, my county next to me changed to implement a new system because their old system had barcodes. How come my county's not doing that? And so, I think ultimately there is a lot of confusion amongst the voters. And I can only see that getting heightened if we do not get kind of clear guidance or clear answers as to the legality of it in the first place, so that we can come out and say, no, this, the EO is no longer being implemented, and this is why and how. And so again, but I also think that that's part of the reason of the EO. I think kind of the underlying purpose is to create that chaos, to create that confusion, to create that distrust in our overall elections process.
So we're coming up on time here, but I want to just go back to all three of you for any sort of closing thoughts or prognostications about where you think this is going to wind up. So, Bo, I'll start with you, and then we'll go to Howie.
I think I agree with Justin from the opening that at the end of the day, the operative provisions of this EO are not ever going to take effect because they're far beyond the scope of the president's authority. And we're really going to have to count on our state and local election officials, as we do for every election cycle, to hold the line and to continue to implement abide by their state laws and to administer free and fair elections for Americans all over the country. And I have faith in that, although it's going to be hard work and it's going to be 2020 probably times X all over again.
Thank you. Howie, any closing thoughts or prognostications?
Yeah, I wish I had a crystal ball, and if I did, I would not have this job. But I would say, you know, I'm not going to rule out that the EO is overturned by the courts or what have you. But I'm also not going to rule out the possibility that Congress passes a law that essentially enacts the major provisions of the EO. So that's always a possibility. And if that happens, Congress does have the authority to make the rules when it comes to federal elections. And, I think this is going to be a much longer conversation than maybe any of us really appreciate. I think from the administration of election standpoint, I actually think this might help some vendors. I think we're going to see an increase in vendors having direction now we know what kind of equipment we have to create. And that's going to create more of a push for states. And I come from a top-down state where we have a statewide voting system. All the counties have to follow the same rules. So that's my perspective. I can see vendors taking advantage of the chaos and pushing to sell voting equipment that does comply with the executive order. Now that's gonna have to come. Somebody's gonna have to pay for that, but I can see that being a thing in the next year or two. So sometimes the best thing for us to do is nothing, which is what we're doing right now, and just waiting to see what happens. But I'm not ruling out, whatever happens with the executive order, Congress is still there. So that's always a possibility.
And we'll go, Ryan, with the last word, which is always a dangerous place to be.
Yeah, I mean, obviously, the courts are going to make the determinations. I have to defer to Bo and Justin as the experts on that, where that will turn out. And I'm going to second what both Howie and Bo said in regards to the conduct of the election. It is going to be another free, fair, secure, accurate, accessible election. Conducted by elections officials, because it is their job, it is their duty, it is what they spend every single day doing. But it's not going to be easy. It's going to be very difficult for all of us that are in the election infrastructure community. But it's going to be extremely difficult on them conducting it because of the chaos and confusion that the voters are going to have. But ultimately, like I said, we'll have free, fair, secure, accurate, accessible elections moving forward, as we have in the past, because of the dedicated elections officials who do this every single day. So I'm thankful for them being there, and all of us will continue to try to shore up and get past the chaos and confusion and inform the voters how secure and accurate those elections will be. But ultimately, we'll have a free, fair election.
Thank you. And thank you again to Bo, Howie, and Ryan for joining us, and to Judd and the Humphrey School for putting this together. And with that, I will turn it back to Judd.